Heyo, folks! Welcome. Today, maybe an hour ago, I saw that this was published. It is defendant Karen Reid's motion to compel Nicole and Brian Albert, Jennifer and Matthew McCabe, Ali McCabe, and Brian Higgins to attend depositions and produce documents pursuant to non-party subpoenas. Now, you might have noticed I don't cover every document that is filed, mainly because most is boring. This one isn't, and it will be an absolute joy, I reckon, to go through these 56 pages of keel hauling from the Karen Reid defense. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
All right. Oh, and hello, folks, by the way. Hello. Good to have you all. Good to have you all here. Taylor Ferry, Tori Massey, hey Rob, RJ, and the rest of you. And hello, you guys over at Rumble as well. Good to have you all here. Yeah, folks, let's get right into this. Should I be up here? No. Maybe if I do that. Yeah, this will be fine. This will be fine. I'm having it the document on a separate screen. So if you wonder, why is he looking over there? Document. Hi, Gwendolyn. Hi, Sherry. Yeah. Commonwealth of Massachusetts Superior Court Department. Plaintiffs, defendants, civil action, yada, yada, yada. Defendant Karen Reid's motion to compel Nicole and Brian Albert, Jennifer and Matthew McCabe, Ali McCabe and Brian Higgins to attend depositions and produce documents pursuant to non-party subpoenas. Memorandum incorporated. Now, something is weird with the document because all of a sudden you see crap like this, but I will do my best to read it anyway. Defendant Karen Reid respectfully requests that the court compel Nicole and Brian Albert, Matthew and Jennifer McCabe, Ali McCabe and Brian Higgins, collectively delinquent non-parties. Remember when they started filing, we are not the House defendants, we are the state witnesses or something like that. Well, if they can rename it, so can the defense. Delinquent non-parties. That is so good. That is so good. Oh. To produce documents and attend the depositions pursuant to validly issued subpoenas. Specifically, the delinquent parties or the delinquent non-parties refuse to produce required documents and refuse to show up for deposition on required dates pursuant to the subpoenas. As a result, Reid seeks a court order requiring the delinquent non-parties. This is how it looks. I can't do anything about it. Requiring the folks to immediately provide 3 non-overlapping dates for deposition between the date of the court order to July 17, excluding June 26, July 3rd, and produce all responsive documents pursuant to the subpoenas previously served within 10 days of such order. The delinquent parties' counsel accepted service of the subpoenas to each of them on May 5th, 2026. A true and accurate copy of the correspondence regarding acceptance and subpoenas themselves are attached as Collective Exhibit 1. However, Exhibit 1, blah, blah, blah. The delinquent non-parties did not serve objections to the subpoena within the 10 days provided by mass civil procedure, yada, yada. Instead, almost 4 weeks later, on June 1st, the delinquent non-parties counsel served purported objections, objecting to everything of producing no documents, and then indicated that the delinquent non-parties were available for the dates included in their subpoenas in early June and mid-June, and that the subpoenas were merely proposed dates that they apparently reject unilaterally. And accurate copies of the delinquents non-parties counsel email and attached responses and objections are attached as Collective Exhibit 2. Yeah, this is a civil matter, but your subpoena doesn't make suggestions. They say, here's the date. If you can't, tell us, object in good time, which is within 10 days of being served. And they didn't. The cowards ran. And isn't it strange, folks, that these fuckers sat beside the O'Keefes during 2 trials, whispering sweet nothings in their ears, with fake outrage over what had happened. They stood by the O'Keefes until it was time to sit down and actually do something for the O'Keefes. The moment they had the chance of helping the O'Keefes in their civil case, they scattered like rats. Isn't that strange? That's a hypothetical question. The answer is nobody is surprised. The McAlberts and Higgins just scattered away. Nobody. Oh, hello, Gigi. Good to have you here. Hello, JKD back. I saw Jen, the couch fairy, earlier. Yes, I did. Hello, everybody. Good to have you here. Where were I? Where was I? The delinquent non-parties counsel did not provide any explanation for their unavailability, writing only, with respect to the depositions, our clients are not available on the dates proposed in the subpoenas and listing dates. He said were available, almost all of which were on or after July 20th. Thus, nearly a month after they were served and just 9 days before the deposition was set to begin, the delinquent non-parties purported to unilaterally postpone all of their deposition except for one for a month or more. Here is a footnote. As described in Reed's pending motion to compel Colin to appear and produce documents, Colin, who is represented by the same counsel as the delinquent non-parties, seasonally objected to the subpoena to him, but then refused to produce documents, failed to promptly provide available future date for deposition, blatantly at the last moment, indicating he would only be available for 2 single days the very next week when counsel was not available and not available afterwards. GD is here and saying, we are about Folks, only a third of you have hit the thumbs up. I know you're here. I know you're watching. Now, maybe some of you are hate watching. I don't know. I doubt it because I'm very, very lovable. So please, the thumbs up. Thank you. Angela, I did. Yay. Let's see it. The rules do not permit non-party subpoena recipients to control the timing of their own depositions. Of course, Reed's counsel was and is willing to accommodate reasonable scheduling for conflicts and concerns, and was willing to reorder the delinquent non-parties' depositions or take them on other dates within the same time range. But that is not what the delinquent non-parties have unilaterally declared. If Reed is forced to wait until the limited mid-July through mid-August dates, that the delinquent non-parties as the fuckers, I can't say delinquent non-parties all the time, and I don't think YouTube will allow me to say fuckers every time those words are in there. Let's just say the McAlberts. Blah, blah, blah. The court's discovery period, which Reed has worked diligently to comply with, will be placed in significant jeopardy. Therefore, Reed requests that the court order each of the McAlberts to provide 3 non-overlapping dates immediately for the next 30 days, except for June 26th to July 3rd for deposition, which is now. Finally, regarding documents, the McAlberts have directly violated Rule 45. Their objections, if any, were due within 10 days after service. They did not file any objections within that period. Nor did they request an extension of time. Ooh, that's good. Steve says, just say wankers. Yeah. Let's try that. Yeah. They did not file any objections within that period, nor did they request an extension of that time. Rather, the time during which they had to object came and went without objection. 7 days after the Rule 45 objection period expired, they emailed what they called objections. These objections, however, have no effect under the rules. Moreover, this is yet another example of unexcused delay, which the court should not continuance at this juncture among any counsel, including the wankers and their counsel, who are watching every hearing in this matter. Failure to object to subpoena within the time provided by the rules ordinarily results in waiver of such objections, especially when there are no extenuating circumstances. And they cite a bunch of cases. And more cases. Oh, that's a lot of... Yeah, let's just say this wall of case law supports Karen Reed's defense. Therefore, Reed also requests that the court order each wanker to provide all documents responsive to Reed's subpoenas within 10 days of such order. Respectfully submitted, Karen Reed. Certificate of service. Exhibit 1. From Murphy. Saying thanks, Chas received. Okay. And this is Mr. Waters. Per your agreement to accept service on behalf of the above referenced individuals, kindly see attached subpoenas. And here's the answer. Thanks, Chas, received. Yep. Let's see here. What else do we have here? Subpoena ducis tecum, which more or less means here's your fucking subpoena. in layman terms. To Jennifer McCabe. Greetings! You hereby are commanded in the name of the Commonwealth of Massachusetts, pursuant of Rule 45 of the Massachusetts Rules of Civil Procedure, to appear and testify on behalf of defendant Karen Reed at the offices of Sheehan, Finney, Bass and Green in Boston on June 27th, 2026, and to testify as to your knowledge and the taking of the deposition in the above entitled action before a notary public in and for the Commonwealth of Massachusetts. The deposition will continue day to day as necessary and will be recorded stenographically and by audio-visual means. Furthermore, you're required to produce the documents listed in the Schedule A attached hereto by June 1st, 2026 at 12 p.m. Well, that would be in... Oh, June 1st, not July. That was a month ago. Respectfully submitted. La 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 la. Definitions, yeah. All the things. Schedule A, yeah. Jennifer McCabe is required to produce by June 1st at 12 p.m. the following documents. All documents, including communications relating to Karen Reed, relating to John O'Keefe, relating to Michael Proctor, relating to the investigation, relating to the criminal trials, relating to the civil actions, all communications with Michael Proctor, all communications with John O'Keefe, all communications with Paul O'Keefe, all communications from January 28th, 2022 to the present with Nicole Albert, Julie Albert, Carol Roberts, Courtney Alberg, Alison McCabe, Chris Albert, Brian Higgins, Brian Albert, Matthew McCabe, Colin Albert, Brian Albert Jr., Brian Tully, and or Yuri Buchanan, collectively known as the Thunderwankers. Oh, hello, Mr. Jingles. Hello. Are you having a good day, Mr. Jingles? Yeah. It's finally cooled off outside. Yeah. And let's see here. Another subpoena. Alison McCabe. Greetings! You're hereby are commanded. I love the starting with greetings. Like, this is positive. I don't think no. Yeah, it's the same thing. All communications. Yeah. So these are Brian Albert. And here comes the one, two. Brian Higgins. For you who don't know, my prime suspect in this is Brian Higgins. He had means, motive, and opportunity. Now, what speaks against him is he is a soft, stupid asshole. He's a beta human. So, which leaves, well, other probable suspects from within the house, which he, I believe, in a moment of weakness, which is his entire life, somehow agreed to the cover-up. But it's the same type of subpoena with the same language and everything. And then you have the Matt McCabe. So these are just all the things to Nicole Albert. Yeah. Is it anything else to this? I thought this was 56 pages. I love 56-page documents, but this seems to be, how many pages was it? at the end. It was just 7 pages. Just 7. No. And the rest are exhibits. Meaning, yeah, here are the subpoenas. Here are all the subpoenas. Now I want to find something else here. Hold on. Ow, Mr. Jimmons. Hold on here. There's a retard on X. Sorry. So there's something wrong on Twitter. I have to reply. Sorry for. Hold on here while I get us some more documents to read. Now, when you're already here. This could be interesting. Hold on here while I open this up. Dun, dun, dun. Stop sharing that. And start sharing this. There's a bunch of these going out. This is answers to, hold on, let me put myself out here. These are answers because the judge says, yeah, who leaked? Who leaked? So this is one of these answers. This from Mr. Rosenberg, Attorney Rosenberg. I certify that I am not aware of any facts as to any dissemination to anyone other than parties and counsel in this matter of any of the contents of the material impounded by the court's order on June 8th, 2026, signed under the pains and penalties of perjury. And I do believe most of the lawyers involved has signed that. But that now, what is my guess as to who leaked? I would say Proctor himself. Now we know he is a fan of the Austrian painter, and he doesn't like anything but the color white. He especially dislikes women and men who are not white. So my guess, it is Proctor himself, because it will buy him time, he believes. Because he's a moron. Neo-Nazi moron. I don't think his lawyer knew. But until we know who leaked it. Now, I haven't seen it. I don't care what it says. I will not, on this channel, read out medical records who are not part of the record of a trial. Not going to happen. Never going to happen. Not on this fucking channel. So this is one of the things. And what else do we have going forward? Let's see here. Dun, dun, dun. Oop. Let's see, what else do we have out of this one? Oh, make myself small again. Plaintiff's motion to compel responses to plaintiff's supplemental keeper of records subpoena from Aidan Kearney. Now come the plaintiffs in the above captioned matter, and hereby moves this honorable court pursuant to Rule 45 of the Massachusetts Rule of Civil Procedure and other relevant rules governing discovery to issue an order compelling Aidan Kearney to produce all documents and materials responsive to plaintiff's supplemental keeper of record subpoena. On April 21st, Aidan Kearney, Turtle Boy, was served a supplemental keeper of the record subpoena, which superseded and replaced in its entirety a prior record subpoena served upon him on April 14th. As of the date of service, plaintiff have yet to receive responses, objections, nor any request for extension from Aidan Kearney. Now, this is just for this is showmanship. This is just playing games. Aidan Kearney is under currently, he is criminally indicted. They won't get shit from Aidan until that matter is resolved. And they know that. So this here is absolutely useless. Now, I don't know the ins and outs of if, how, when, or if not, how and when Aidan's representatives have answered this. Nor do I care. Because it's absolutely useless until the state drops the charges against Tully. So that is my brief and honest opinion regarding that shit. And we let's see what else is new. Yeah, the motion to compel. We already went through that. Here's a new document. Hold on. Yeah, Brian Tully. Another one of these wankers decided also to not attend, or try to not attend. Isn't it strange that everybody runs? Well, when it comes to Tully, supervisor. Not only supervisor over Buchanan and Proctor, but also supervisor over the team that did the extractions of the phones, or in many cases, lack of extractions of phones, because, screenshots, that's enough, apparently. But also Brian Tully, the coward, smart, but still a coward, is the one whose team in the Sandra Birchmore case extracted but didn't see 32,000 messages between Sandra Birchmore and her groomer, rapist, and eventually probable killer, going back to when she was a minor, when the grooming started and the grapes started. Tully and his team claims to have missed all of them. That's the type of person Brian Tully is. And now the fucker is teaching new cops on how to do extractions of phones. So this is that document regarding non-party witness, Lieutenant Brian Tully. He's no longer... He's retired. Motion for leave to file a corrected memorandum. Non-party witness, Lieutenant Brian Tully, retired. Through counsel, respectfully moves for leave to file a corrected citation in his memorandum in support of his motion to quash, subpoena, and or for protective order. After filing the memorandum, counsel discovered that one citation on page 6, section 1A, inadvertently cited an incorrect Massachusetts case. Yeah, this is filed June 30th. The collective mind of the Free Karen Read movement saw this over a week ago, and of course, many pointed it out. You know what this reminds me of? AI filing. Now, for what? Let's just say his attorney got lucky, because if everybody hadn't spotted it, that would be what was on the record. Now, I do believe the judge allowed this, but where is it? Or is it up here? Respectfully submitted. Let's see, what does it say? Yeah, here, allowed. Or here on the side of the page. So the court allowed them to correct this. Now, I haven't looked into much of what he claims, that I wasn't involved at all, or whatever he said. Well, his testimony in 2 trials kind of says, yeah, you were, weren't you? So, Mr. Tully, place your ass, be recorded, so eventually we can see what you try to get away with. Why don't you do that? It's not like you have much choice, because here as well, he filed it late. GD says, be right back. Baby stuck in toy box. GD, get my niece out of the toy box. Oh. Yeah. The baby GD is referring to is her granddaughter. And granddaughter likes my voice. So sometimes when granddaughter is a bit on a bad mood, did you plays my streams? It's very, very sweet. It's very, very sweet. Let's see, what else do we have here? Because there's a lot of papers. Yeah, there's a hearing scheduled relating to the order of, which is today at 3 p.m. I now don't know if it's live streamed, but there is a Zoom meeting ID. But the availability is to be determined. This is one of the, I do believe, since this is such a sensitive matter regarding Proctor's medical records, you know, he got into a wee woo cab off to the loony bins. Swamper says it's harder than the armpit of Hades here in South Carolina. Yeah, we had a heat wave over here over the weekend. So where it was in freedom units, 90 degrees or more, and no wind. Folks, our houses are built to retain heat, because over here it is cold and wet and dark 10 months of the year. But this weekend over 90 degrees, which is equivalent of, I believe, 150 degrees in South Carolina. We're not used to it. We like cold over here. Okay, let's see. Do we have any more updates? Dun, dun, dun. Dun, dun, dun. Supplemental notice? What is this? When did I miss this? Oh yeah, this is the one we were talking about earlier. Hold on here. Dun, dun, dun. This is from non-party witness Lieutenant Brian Tully. Through counsel, respectfully submits this supplemental notice to clarify and supplement the motion for leave to file a corrected memorandum. And we now know that it was approved. What? I thought there was a bunch more. Oh, yeah, then you have the opposition. Oh, the opposition of motion to compel. Hold on here. Let's see here. Here you go. No, wait a minute. This is Defendant Kearney's reply to non-parties Nicole and Brian Albert, Jennifer, Ali, and Matthew, and Brian Higgins' opposition to a motion to compel. When was this filed? 6/29. So Monday. Why was then this? Oh well, let's read it anyways. Because I really don't care about what the collective known as the wankers has as excuses. Okay. Damn, I have so many tabs up. There it is. Defendant Kearney's reply to non-parties Nicole and Brian Albert, Jennifer, Ali, and Matthew McCabe, and Brian Higgins' opposition to a motion to compel. Delay appears to be the goal, and not just a symptom of the manner in which Nicole and Brian Albert, Matthew and Jennifer McCabe, Ali McCabe and Brian Higgins, collectively the delinquent non-parties, have responded to defendants Karen Reed's subpoenas. In response to validly issued subpoenas, these individuals ignored Rule 45's deadline for objecting to document production and belatedly claimed that almost all of them were fully unavailable for more than a month from their subpoena dates, evidencing their desire to obstruct Reed's ability to take discovery required for her defense. Indeed, in the 9C conference concerning these subpoenas, among other topics, the Wankers Council even suggested that Reed's counsel should simply accept the late deposition dates his client has chosen, because by the time the court heard and decided Reed's motion, all of the interceding time would have passed anyway. Rule 45 has specific deadlines and requirements so that a party to a case may compel witnesses to provide discovery in a timely manner while respecting the non-party's right to avoid undue burden. Although Reed has always been willing to... Isn't this the same one? No, it isn't. Sorry. It's just a bit of the same language. Although Reed has always been willing to accommodate reasonable scheduling conflicts by choosing new dates in the same time frame as the subpoena date, the court should not permit these non-parties to unilaterally impose their will on the discovery schedule in this case and prejudice Reed's ability to prepare her defense within the discovery period. Reed replies separately to the Wankers' arguments regarding document production and deposition dates below. Document production. In their opposition, the Wankers claim that good cause and good faith support their failure and refusal to assert timely objections within the 10-day window set forth in mass blah, 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 blah. But they provide no explanation for why they ignored Rule 45's deadline. Instead, they simply rely on the very objections they belatedly asserted as a reason for the court to ignore the deadline. The court should reject this circular reasoning, which would render Rule 45 toothless. This is why, quote, failure to timely and properly object to the subpoena generally constitutes a waiver of all grounds for objections. And or the case law. The Wankers then asked the courts not to compel them to produce any documents based on a single paragraph in reference to an opposition filed in response to a different motion by a different party, Colin Albert. However, much of Colin's opposition is distinguishedly because it focused on the fact that he claims to have left the house at 34 Fairview Road before Reed and John arrived in the early morning of January 29th, 2022. In stark contrast, the wankers, other than Ali, were undisputedly in the house at that time, and their alleged conduct forms the core of the, quote, false narrative that plaintiffs allege Reed promulgated, causing them compensable emotional distress. To the extent these individuals have communications concerning the major aspects of Reed's defense or quote-unquote narrative, they are relevant and must be produced. If the wankers had concerns about specific requests and the burden they would impose, they were required to, at the very least, describe them to the court with sufficient specificity so that the court could balance that burden with Reed's need for this evidence. But they have not done so and have never identified any such specific burden to Reed. And it was particularly important for these particular subpoena recipients to specifically identify any undue burden they claim to be facing, because many of them are also plaintiffs against Reed in the separate defamation case pending before this court relating to the same quote-unquote narrative, a role they voluntarily took on, knowing that it would require them to gather, review, and produce whatever responsive documents they might have. Oh, hello, friend Psycho over at Rumble. Good to have you here. Good to have you here. And you over at Rumble, I know there's more than friend Psycho watching. Please at least put a smiley in the chat, please. Okay. Let's continue. Deposition dates. As to the wankers' deposition dates, this reply can be brief. Reed offered to reschedule any of the dates to others close in time to the originals to accommodate reasonable availability issues. The wankers simply repeated the dates they had proposed in the first place, ignoring Reed's right to take the depositions comfortably within the discovery period, rather than facing the task of taking multiple highly relevant depositions in rapid succession at the end of the court's discovery schedule. Third parties' rights to be free from undue burden does not allow them to unilaterally dictate the deposition schedule for this case in this manner, and the court should prevent them from doing so. Yeah, that is a damn good reply. Damn good reply. And folks, one of the reasons why the Reed team wants to depose them in a certain order. Now, this might be obvious to many, but they know who said what lie in the trial, in the grand jury, to the feds. So in the order they want these people deposed is to glue them down to specific statements. And then over to the next one. Just hammer it down. Oh, really? That's, you said this on that date? What is your story now? And it's their right. It is the Reed team's right to do this. Now, the Wankers legal team knows this as well. They know all these tactics. They have been around before. But that doesn't allow them to ignore the rules. It simply doesn't. It might have worked with Judge Bev, but Judge Bev isn't here anymore. So this as we now are in July, and the deadline is, what is it? End of August. There is extremely limited time to get this through. Hence, and also, this is also good timing because the latest actions from the court, from the judge, has indicated he's fucking fed up with the games being played. Hence, motion to compel with the language they use, in the hopes that this will reveal to the judge Karen Read is doing everything she can. She sat down for her deposition, giving her testimony for the first time under oath. Hopefully, the motion to compel is successful. Hopefully, they can finally get the wankers, also known as Nicole Bryant, the McAlberts and Higgins, especially the McAlberts, because Higgins has already been testifying here. Proctor is another story, but my hope is, I mean, they are having a hearing at 3 p.m. Eastern today. My hope is at around 4 p.m., the judge have had his answers regarding the so-called leak and can move on to the motion to compel. Look at the representations or the lawyer for the McAlberts and Higgins and say, get your clients their ass in seat that date and that date and that date, and produce documents before. Your asking was too late. Hand the fucking papers over and sit your client's ass down for depositions. I don't think he will say that. You know, maybe not in those words, but my hope is he's fed up enough to come close. All right. Do you have any questions? Because I can't find anything more interesting in the past week or so, at least. Oh yeah, I forgot. Hold on. They found Yuri. Yuri is on a cruise, or was on a cruise at least. Hold on. There he is. Yeah. That, by the way, if you recall, is the same guy who under oath said, I don't know the meaning of that word because English is not my first language. And there he is, drunk as a skunk on a cruise, which is not bad, by the way. I've been drunk as a skunk on cruises. It's kind of required, almost. See, I was once, between Sweden and Finland, there are cruises. There are Finnish-speaking cruise ships and Swedish-speaking cruise ships. I got on the wrong one. I got on the Finnish-speaking cruise ship. So, alcohol was involved. I did karaoke. Finnish karaoke. Apparently, it was quite popular. So, that in itself, I don't blame anybody for being drunk as a skunk, but it is funny because here he is singing "Proud to be an American" when he under oath said, "I don't know easy, plain English words because I'm not American." The irony makes this funny. All right. I think that is all I had for you. I managed to do all of this in under an hour. Madita Finn asked me, what did I sing? I have no idea. It was some oompa oompa, and then words appeared on the screen, and I sang them as I thought they should be sung. It was very, very popular. At least people laughed. All right, folks. That is what I had for you. If anything interesting happens in 3 p.m. in about 3 hours, I don't think it's... If it's live streamed somewhere, I'm going to watch it, and I'm going to give you guys my opinion about it tomorrow. All right. Now I'm done. All right. Thanks for listening in. You all have a good one. Hit the like, subscribe if you haven't. Watch my other stuff. I have plenty of good stuff for you. See you tomorrow. From me and Mr. Jingles, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. See ya. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus.